Okay, let's go on the record on cause number DC 21122332, Akia Lodgings versus Arush LP. Council, make your appearances.
Your Honor, John Sokatch on behalf of the defendants.
And Your Honor, Don Cololari on behalf of the plaintiff and third-party defendants.
Okay, let's go ahead and proceed.
So Judge, John Sokatch again on behalf of the defendants. This is our motion. It's our motion for summary judgment. If it's okay with the court, I do have a PowerPoint presentation I'd like to put on the screen. So let me pull this up. Give me 1 second, Judge.
We want to file a motion for continuance, and when this
All right, Judge, can you see the PowerPoint?
Yes.
Excellent. And so, Your Honor, John Sokatch again on behalf of the defendants, Arosh LP and Addy Holdings Management. This is our defendants.
You're having some feedback.
Yeah, I think we got it fixed. So, Judge, here's what we're asking for today. We're asking for summary judgment on three things. One is on our request for declaratory relief. Two is on the plaintiff's count one, breach of contract. And third is on plaintiff's count two for attorney's fees. At a high level, what this case is about is you have Aquila Lodging, the plaintiff, is seeking recovery of fees under a management agreement that it had with my client, the partnership, Arosh LP. My client terminated the management agreement on August 2nd, 2021. And what Aquila is contending in this case is that they want payment of fees effectively for 5 years after termination. So they're claiming that their damages are 5 years beyond what the management agreement, for the remaining 5 years under the initial term. And it's our position, it's the defendant's position that the agreement was validly terminated. There is no right to recover anything beyond that. And alternatively, if there is, then it's limited to this thing called a termination fee that's set forth under the management agreement. So, Judge, in our mind, I think the case has three possible outcomes. One is you grant summary judgment in our favor and the plaintiff recovers $0. Two is you grant summary judgment in our favor, and as an alternative, you say that its remedy, the plaintiff's remedy, is limited to the termination fee. And then the third outcome is, summary judgment's denied and we proceed forward with the case. But we think that, again, I put up on the screen either option one or option two, either $0 is owed or the termination fee is owed is the correct outcome here. So there are four reasons why the management agreement was validly terminated and why either no fee or just a termination fee should be had here. First is that the partnership agreement that the parties signed expressly permits the partnership to terminate the management agreement. Number two, the management agreement itself permits termination. Third, again, this alternative remedy that if termination was done, but there is a remedy available, then at best it's limited to this termination fee. We'll cover it here in a second. And then fourth, I think this is an uncontested point, but nonetheless, we still raised it in our motion, is there's a defendant called Addy Holdings Management, LLC. And it's our position that AHM or Addy Holdings Management cannot be held liable under either the breach of contract theory or the attorney's fee theory. And I'll get to that at the very end. So just some background facts on what we're talking about. This is the hotel that's located at 1580 Point West Boulevard in Capel, Texas. The partnership, Arosh LP, owns this hotel. It owns and it operates the hotel. And the partnership agreement that was entered into was an agreement that allowed parties, limited partners, to invest into the limited partnership and allow the general partner to operate the partnership and then also pick a management company. So here's what you have. You have April 28, 2014, the limited partners and a general partner. Then it was Piro Aro LLC executed this Arosh LP limited partnership agreement. It's Exhibit 1 to our motion. Now, I've color coded these because and it'll be important for grouping here in a second, so you see who has what authority. But effectively, the two red entities, Piro Aro LLC, which was the general partner, and 200 PW LLC, those are entities that are owned and controlled by a gentleman named Suhas Naik. They are what we call the Naik parties in our motion for summary judgment. The other entities in green is the Addy Group. So the Addy Group is my clients. The Addy Group is the party that were permitted to terminate the management agreement under the partnership agreement, and you'll see why here in just a second. So as part of this arrangement, my clients contributed $6.72 million of cash and land into the partnership. So we were the money. We brought the money into the partnership, $6.72 million. We invested that. The Naik parties, the ones that I highlighted in red, contributed a grand total of $0. So my clients contributed 6.72 million. The Naik parties contributed 0, but the Naik parties were the general partner. So you may be wondering, well, why would you do that? Why would a party or why would a group of investors invest $6.72 million, allow the general partner to not invest anything? I mean, why would you do that? And it's really easy. There were these, what we call preferred return rights, meaning contractual rights in the partnership agreement that specifically allowed my clients, the Addy Group, to maintain control over the partnership until they got their return on investment back. So you see in the affidavit of Zenobia Addy, who's our corporate representative, she says that the only way that the Addy Group would invest in this project, where we contributed 100% of the land and money, and the Naik entities contributed $0, is through these contractual checks and balances that we're going to call preferred return rights. So you'll see what these are in just a second. So what are preferred return rights? There was a distribution waterfall schedule. I'm sure the court has seen this before, but effectively you have partnership distributions that can be made, and it's done pursuant to a waterfall or a bucket schedule. So you've got a bucket that's filled up with water and tips over once the bucket's full. So same thing applies here, is you have a distribution schedule, and the buckets in consecutive order have to be filled up before distributions can go to the next bucket. So the way this was structured is, unless and until that fourth bucket was filled up, our clients, the Addy Group, maintained control over the partnership. So we had to get a 10% per annum preferred distribution. Then we had to get 100% of our capital contribution back, so 100% of that $6.72 million. And then we had to get a 40% internal rate of return on it. So until these buckets were filled up, we maintained absolute control over the partnership. Now, this is uncontroverted. Are we in the preferred return rights period? This, in paragraph 13 of Ms. Addy's affidavit, she says that to date, we have recovered a grand total of $1.155 million of the 6.72 that we invested. So going back to this going back to the distribution schedule, we're not even past C. We're still in C because we have not filled up that bucket, that $6.72 million bucket, to give our client their money back. So we still have these control rights. So what does that mean? So here's the first one. Preferred return right number 1 said that the Addy Group, and again, Judge, these are provisions that the parties specifically contracted for. We have, the court's well aware of rules of construction.
Just so you know, I have read everything. So you're kind of rehashing stuff I've already read, but so you can go through it a little more quickly.
Understand, Judge. So, well, here's what I want to focus on. This section and one other section I'm about to come up on. These were specifically contracted for rights, and we have to give effect and meaning to them. This section in 7.1F of the partnership agreement specifically says that while we're in this period where we haven't gotten 100% of the distribution, we have the sole and superior right to do these major decisions. One of which was terminate the property management agreement. The property management agreement. We had that right. That was a right that was conferred to us in the partnership agreement. Same thing, we had this right to remove the general partner, which we did. But the third right, the one that we talk about under section 7.1D4, says that if there's going to be an affiliate arrangement, if there's going to be an affiliate.
D4 or D6?
I'm sorry, Judge.
D4 or D6?
Excuse me. It is D6. You're right, Judge. That's my dyslexia kicking in today. It's 7.1 D6. You're correct, Judge. Is that if there's going to be an affiliate arrangement, then the contract has to be terminable without cause on 30 days prior notice and without charge, penalty, or premium against the partnership. And Aquila Lodging, according to this partnership agreement, is an affiliate. So in other words, that management agreement is an affiliate agreement under the partnership agreement that we specifically contracted for and said we have these rights to terminate without cause on 30 days prior written notice without penalty. That's what we've done, Judge. And we've attached summary judgment evidence where you've seen, I think it's exhibit 3 and 4, where we pass a corporate resolution saying we are going to terminate the management agreement. And then we send out this 30-day written notice to terminate. So again, I talked about these are affiliates, but effectively Aquila Lodging is Piro Aro and vice versa. When you look at what the definition of affiliate is, it's any person who directly or indirectly controls or is controlled by or under common control with the other party. So here, Aquila is Piro Aro is Aquila. So whatever Piro Aro consents to, Aquila consents to, and vice versa. And we know that because these parties signed the partnership agreement. Piro Aro signed for the general partner. Mr. Naik individually signed and agreed to the partnership agreement. Therefore, Aquila consented and ratified the terms of the partnership agreement. Now, here's what Texas law says on separate contracts executed around the same time. If they are separate contracts and they are part of the same transaction, then they have to be construed together. And even if they are in separate documents, they don't even reference one another. If they are still part of that same singular transaction, they have to be construed as a single unified instrument. So, Judge, we submit that the partnership agreement and the management agreement have to be construed and interpreted as a single unified instrument.
Doesn't defendant argue, though, that there is a for cause provision here, that they can only be terminated for cause?
So good question, Judge. So let me skip ahead to that. So in the for cause section of it, here's what it says. It says that under the management agreement, under 12.1b, it is not mandatory. What it says is that it's in addition to and cumulative of the other rights and remedies that are available. The non-defaulting party may give notice. So the notice isn't even required. It's a may. It's not a shall. It's a may give notice. And then you have another section, 13.17, says that the rights are in addition to and cumulative of, meaning that we have rights to terminate these agreements. Now, the one other thing is the agreement itself, the management agreement, specifically contemplates a prior termination. It repeatedly references that the agreement, will go for 10 years unless it's sooner terminated or extended as provided herein. Again, we provided a 30-day notice. We gave them an opportunity to cure, if that's what they want to call it, but it was still a 30-day notice that said, hey, we are terminating this effective 30 days from today's date. And that's what we did. Now, again, I've given you this alternative outcome, which is that the court can allow a termination fee to be the remedy here. This is bucket number 2 or option number 2, meaning that if there's a termination, which we did, then they get a termination fee. So we have to give meaning to this provision in the management agreement. And we're fine with that. We are okay if the court says, all right, fine. Well, you terminated, but the remedy is it's not 5 years of fees, it's just the termination fee. And so the court does have authority to allow that. And it actually says in that same section where they say, well, you've got to give 30 days notice. It says that if the owner, my client, defaults, then they're entitled to all unearned management fees, which I don't believe there are any, and the termination fee. That's it. There's nothing else. They don't get 5 years of fees. They get unearned management fees and they get the termination fee. So again, we submit, Judge, that if that's the outcome, then we are okay with that, and we would agree that the termination fee would be the remedy. So, Judge, again, we exercised our rights under 7.1, terminate the management agreement. We provided the 30-day notice, which is Exhibit 4. Again, this is uncontested. We subsequently appointed a new property manager of the hotel. And then what transpired after that is, when you have somebody, often a hostile or contested takeover, is there were demands made saying, please turn over the books and records. Mr. Naik and Piro Aro said, we refuse to do so unless you pay us, seven-figure payout. I think it was $2.5 million. So that's what spawned this litigation. So, Judge, what we're asking for is that you say that we exercise those rights validly, and they are limited to recovery of $0 or that termination fee. So, Judge, I don't want to rehash our argument. I know that I've kind of gone through all this at length. I know you've read it. So, Judge, if you have any other questions, I'm happy to answer those. But again, I think what kind of the salient issues are these two sections, 7.2 saying that, or 7.1F saying that as long as we have a right to receive 100% of the distributions, we can terminate or amend the property management agreement. And then this one under, I think it's 6.2D6, which says that if there's going to be an affiliate arrangement, it has to be terminable without cause on 30 days prior notice and without charge or payment to the partnership. And we think both of those carry the day here. And again, they have to be construed.
What about this termination fee argument?
Well, Judge, that's the problem is there seems to be tension between these two agreements on that particular issue. I mean, you have one agreement that says they get a termination fee, then you have a subsequently executed agreement that says, well, there's not actually going to be any fee. It's going to be a no cost or charge to the partnership, which is why, again, we think the better argument and better outcome here is that no fees are due of any kind, because that is a superseding agreement to the management agreement.
Does it say it supersedes the previous agreement?
So it doesn't, Judge, and I'll concede to you that was one of the problems in drafting. There's no express language there that says that it's superseding the management agreement, but it certainly incorporates it. Recall that the partnership agreement specifically defines the property management agreement, says that the property manager is going to be Aquila, and that they are going to be subject to the PROR would be subject to the terms of that partnership agreement. So it certainly does incorporate it. I skipped over it, and I'm happy to go back through this, but there are also remedies in the partnership agreement itself, which are specifically checks and balances on Aquila. So, for instance, again, these agreements were executed together. Here's where they were incorporated in. This is where the property management agreement was incorporated in, section 2.1 and section 4.2B2D of the partnership agreement. It confers the right for us to terminate the property management agreement, which, again, Aquila, I don't think would be able to challenge or contest. It's a right that's given in this partnership agreement. But then there are also limitations on Aquila. So if you look at 4.2B2D, there's a subordination requirement that says that in certain instances, Aquila has to subordinate its right to payment. There's another one in 8.6 that says that Aquila has to give full and complete real-time access to the Addy group for the books and records of the partnership. I mean, those are limitations or restrictions on Aquila's rights, which, again, when Mr. Naik executed the partnership agreement, those were things that he consented to on behalf of PROR and its affiliate, Aquila Lodging. Again, that's specifically called out in the partnership agreement itself. And here's where that was leading into my last point on this, which is he signed for the general partner, signed individually. Aquila Lodging is an affiliate of the general partner. Ergo, Aquila has either consented to or at least ratified this subsequent partnership agreement. And again, it was a material inducement, according to Ms. Addy's declaration or affidavit that was attached to the summary judgment motion. It was a material inducement for this transaction to allow these checks and balances, to allow my clients to terminate this agreement. Otherwise, you render meaningless those sections in the partnership agreement. I mean, that's kind of the rebuttal to it is, well, what if what they're saying is true, then what do you do with the language that says we can expressly terminate the contract? And I don't think they have an answer for that. So we again submit, Judge, that these have to be construed together and harmonized so that you give effect to each of those provisions. So, Judge, in summary, again, we think that summary judgment's appropriate because we had the right to terminate the management agreement under the partnership agreement. We had the right to terminate under the management agreement. By the way, too, the management agreement, I forgot to add this, does not state that it's the exclusive remedy of termination is only for the Aquila, the manager. It doesn't say that anywhere. It contemplates termination by either party, and it says, here's how it can be terminated, and we followed that. We gave the 30-day notice and cure right. So, and then lastly, Judge, again, I don't really think this is contested, but I really don't understand why Addy Holdings Management is a defendant here. They were the general partner that was installed after the removal of PROR. They're not a party to the management agreement, so we think it's not proper to hold them liable. But the plaintiff has sued Addy Holdings Management. So I think at the very least, that's probably the easiest one you can grant on that one, because we're a complete stranger to that contract. So in summary, Judge, we're requesting summary judgment on our declaratory judgment. Plaintiffs count 1, breach of contract. Plaintiffs count 2, request for attorney's fees. We think that if summary judgment is granted, again, one of the 3 possible or 2 of the 3 possible outcomes are appropriate. Either it was validly terminated and there's nothing due to Aquila, or it was validly terminated and at best or most, the termination fee is what's owed. Thank you, Judge.
All right, response?
Yes, Your Honor. If I may also share the screen.
Yeah.
Are you able to see that, Judge?
Yes.
Your Honor, the argument, much like the briefing, attempts to conflate more than one agreement, more than one party, into just this muddle of, we think we're entitled to summary judgment because these parties are all affiliates. Mr. Sokach in his argument went so far today, never before argued, to say being an affiliate makes you the same party. He said Puro Aero equals Aquila, and if Puro Aero agreed to something, Aquila agreed to it. That's not the definition of affiliate. That's not provided for in the agreement. There's no such rule of law. These are separate entities. Then he said, well, Aquila ratified it. That's never been pled. That's never been raised as an argument. So we're just making things up as we go along. And I'd like to, if I can, take the court back and try to put some, impose some logic on this and actually what do these contracts say?
Okay, go ahead.
The controlling issue is, was the management agreement properly terminated in accordance with its terms? And there's a lot of confusion in the briefing on the part of the defendants as to essentially equating termination and breach or failing to distinguish those things. Termination of a contract may or may not be a breach. If a contract is terminated in accordance with a right provided by the agreement, it is not a breach. And the Gulf Liquids case, which I believe defendants themselves cited, makes that point. They call it a termination without cause or a termination for convenience provision. If you have one of those and you can invoke it, then it gets you off the hook from any further obligations without putting you in breach. However, an unauthorized termination is a breach of contract as a matter of law. And that's the Dallas Court of Appeals case, 2 cases we've cited here, Shenglun and Pinnacle Anesthesia, standing for that proposition. So the question here is, did Aroche have the authority to terminate the agreement for convenience or without cause? And under the management agreement, contrary to what Mr. Sokach says, they clearly did not, just clearly. So let's look at the management agreement provisions first. Let's start with this. Their notice of termination that they cited to you two in the argument invokes section 2.3 of the management agreement. There is no section 2.3 in the management agreement. The evidence we've offered, uncontroverted at this point, is that the Addy group proposed to include language, that section 2.3, authorizing them to terminate for convenience, but it was never agreed to. They wanted to amend the management agreement to do that. I submit to the court that that fact by itself, before you get to anything else, requires the summary judgment to be denied, because we've got this inherent contradiction in the plaintiff's, the defendant's own summary judgment evidence, where they are citing to a management agreement they've attached and saying they terminated pursuant to a provision that's not even in there. Now, beyond that, when we get to the substance of the management agreement, the management agreement says in section 2.1 quite clearly, It's only terminable in accordance with its express provisions. Now, we cited that in our response, quoted that language, which is here on the next slide for the court. And the defendants didn't even respond to it. To this day, still have not even acknowledged section 2.1 of the management agreement that says it can only be terminated in accordance with its terms. There's a second provision, section 11.1 of the management agreement, that says Aquila is entitled to remain as manager so long as they're not in default. Well, that obviously dovetails with section 12.1, which is the one provision that gives Aroche authority to terminate the contract if Aquila is in default. And there's the language in section 11.1 that says the owner being the partnership warrants that as long as you're not in default, you shall be entitled to operate the project. So we've got a provision. We've got no provision in the management agreement saying termination without cause. We've got a provision that says it can only be terminated in accordance with its terms. And we've got a provision saying if you're not in default, you have the right to operate and stay as the manager. Mr. Sokach then cites, well, there's provisions in the contract, in the management agreement that says it's possible that this thing might terminate prior to its stated term. And its stated term was 10 years with automatic yearly renewals at the end of 10 years. And he's right. There are a number of ways in which the contract can be terminated early. Section 2.2, if you don't renew it timely, if you don't object to the renewal timely at the end of the 10-year term or the subsequent renewal terms, then it will be renewed. But you can give notice of non-renewal, and it will terminate. Section 10.2 gives my client Aquila the right to terminate the management contract upon a sale of the hotel. Section 12.4 gives Aquila the right to terminate if the hotel loses its authority legally or its ability through a force majeure to be able to operate the hotel. And finally, section 12.1, which provides that either party has the right to terminate with notice and opportunity to cure upon a default of the other party. So we've got sensible reasons why the contract provides in various places that it might be terminated before the end of the stated term. And there's absolutely no basis to say that that language that says it might be terminated earlier gives rise to this implied right of termination for convenience. It's simply not in the contract. The contract actually affirmatively negates it. So there's simply nothing in the management agreement that the defendants could possibly hang their hat on to say they were allowed to terminate this without cause. And that's what they did. They sent a notice that they were terminating. They didn't say there was any default. They haven't tried to show there was any default. They haven't even alleged there was a default. So it is a termination without cause notice that they sent and that they're trying to enforce here. And the management agreement simply doesn't provide for it. Which brings us to the other argument, the main argument that defendants are making, which is, well, the partnership agreement says we have that right. And I want to examine that a little more closely because there's a couple of points here I think that we need to focus on. Number one, this is not a situation where parties are saying there are more than one document that makes up a single unified contract. Those are the cases that were cited by the defendants in their reply brief when they raised this read the documents together argument for the first time. For example, one of the cases they cite, and these cases typically arise in connection with whether or not a document or a contract includes a jury waiver or an arbitration agreement or a forum selection clause, and one contract does and one contract doesn't. So they cite a case involving a guarantee that didn't include the jury waiver that the other side wanted to enforce. But the court said, well, in the guarantee itself, you agree to comply with all the terms of the underlying loan agreement, which has the jury waiver in it. So we've got a single unified contract and we read those together and you're bound by it. Likewise, in the other case they cite, they're dealing with a purchase order that doesn't have a forum selection clause in it, and a later agreement for the purchase of that item that contains an integration clause saying this is the final agreement and everything else is rolled up into this. And the court said, well, the waiver is in that agreement. The forum selection provision is in that agreement, that we read these together. You've agreed to it. You even sued on it, citing that agreement. So we're not dealing with a case like that. What are we dealing with? There is the case law that related contracts executed by the parties in a transaction should be read together if possible. But that rule doesn't have any application here at all, and I'll explain to the court why. It is a rule of contract construction, contract interpretation. And this is a quote from the Ryder v. Woods case from the Texas Supreme Court just a couple of years ago. The purpose here is to try to ascertain the intent of the parties. We construe a contract that gives, through a contract in a manner gives effect to the party's intent. And if the court notes the highlighted language at the end, when you're doing that in construing different documents together, the court says it's important to keep in mind that we're only doing this for purposes of ascertaining that intent. And we just can't apply that rule arbitrarily and without regard to the realities of the situation. Now, in this case, that has a special resonance because of the fact that we have a management agreement that explicitly says you can't terminate this other than for cause. There's no other termination right that the partnership has in the management agreement. And the Dallas Court of Appeals case and in this Saba case makes this point. The rule of construction about reading documents together cannot be used to override and rewrite an express provision of a contract. So you can't take the management agreement and say, read it together with the partnership agreement, and you now essentially just completely write out the material terms of the management agreement and incorporate terms from the partnership agreement. So for that reason, there's no way to pull things over from one agreement to the other. Now, there are other reasons why, in addition to that, just blatantly no longer looking at the intent of the parties as expressed in the management agreement, other reasons why this interpretive rule wouldn't be applicable here. The contract is not between the same parties. As I mentioned a bit ago, this is not Piero Arrow. This is not Mr. Nake, who is the property manager. It's a separate legal entity, Aquila, that yes, is an affiliate of the general partner, but is not the general partner. And there's no indication anywhere in that partnership agreement or in the management agreement of Aquila binding itself to the terms of the partnership. What's interesting, and again, the Ryder v. Woods case from the Supreme Court is instructive here, that without something that does that, we're not going to ignore the well-established principle that these companies are legally distinct from their managers and their members. We're not going to just write that out under the contract interpretive rule of read contracts together. The Columbia Hospital case out of the Fifth Circuit does the exact same thing, makes that point, citing Ryder just 2 years ago, and says, we agree that the problem here with trying to make that argument is that the entity they were trying to enforce it against never agreed to comply with or be a party to those provider agreements. And this distinction is critical. It is critical because we recognize the separate nature of these entities. And from defendant's standpoint, they're just going to blow through that and ignore it. Doesn't matter. But they can't. And Mr. Sokach pointed to this earlier. I think it's telling, but in the exact opposite direction that he does, apparently. Mr. Nake individually, not just as the manager of the general partner, but individually signed the partnership agreement. And it says why he's doing it. He's doing it to ratify and confirm certain agreements being made in that. Aquila did no such thing. Mr. Nake did individually. Aquila did not. What else tells us that this interpretive rule can't override the clear terms of the management agreement? Well, the management agreement has a merger clause. And the Supreme Court, and this is the merger clause, says this is everything. This constitutes the entire agreement. And what the Supreme Court has says, the existence of that merger clause confirms that the agreements are separate and distinct from one another, and the parties did not intend otherwise. So for that reason as well, this read documents together and just ignore who the parties are argument doesn't work. Finally, I'd point out that the argument that defendants are making, which basically says in the partnership agreement, it says we're supposed to be able to amend or terminate, and using that to modify what the management agreement says is going to lead us to absurd results. The partnership agreement, the provisions that Mr. Sokach has cited you to, all relate to what is the authority of the general partner to act on behalf of the partnership. It's the whole section that these provisions appear in, and in what types of decisions can the general partners not have that authority to act alone, but requires the unanimous consent or the consent of the ADI group to take certain actions. So all those provisions are talking about defining the authority of whom to act on behalf of the partnership. They're not purporting to define what the agreements with third parties are say. Now, if I can, just for a moment, point us to this is part of 7.2, which is the major decisions provision that Mr. Sokach was pointing to. And he talks about the right to terminate or amend any material term of the property management agreement being a major decision, which means it's the ADI's decision to make so long as they're in the preferred return period, which he's correct, we don't dispute they are. But again, that's talking about the authority to act on behalf of the partnership. It's not talking about whether or not the management agreement allows that or not. We've got the provisions here about the same thing would be said about terminate or amend any material term of the Hope franchise agreement, terminate or amend any material term of the economic incentive agreements with the governments. These are not standalone provisions allowing the ADI group to ignore the terms of the franchise agreement, the terms of the local government agreements, or the terms of the property management agreement. Mr. Sokach's position is not only could they terminate, they had the unilateral right to amend it. So I suppose he's saying they could decide.
That is what it says, though, isn't it? It says terminate or amend.
It does, but only if the court looks at it in the context of where it comes from, which is it's talking about who has the authority on behalf of the partnership to act. So if there's going to be an agreement to amend a property management agreement, to amend the franchise agreement, the general partner under this partnership agreement could not enter into that himself. This is a major decisions provision. It's talking about as between the general partner and the limited partners acting unanimously, or the ADIs acting while they have the preferred return period, who has the authority to act on behalf of the partnership. there's no way in the world that this could be construed to say, yep, the Addies have the right to amend the franchise agreement all by themselves, or that they have the right to amend even Aquila's management agreement all by themselves. They're going to make Aquila an indentured servant. They got that right? Of course not. That's not what these provisions are intended for at all. That's not what they say. And so you have to put these in context of if you were trying to read these together, what is this addressing versus what is the management agreement addressing? And Your Honor, that ultimately brings us to what I think is the fundamental fallacy of their whole motion. They're not arguing, at least not in any good faith way that you could find in the management agreement, that the management agreement actually includes a termination for cause provision, for convenience provision. What they're saying is the partnership agreement says it was supposed to. That's really the argument. The partnership agreement says it was supposed to, and we're the ones who are supposed to decide if it's terminated on behalf of the partnership, and so you can't challenge that. As I say, that's an issue ultimately of the authority of the general partner to have entered into the management agreement in the first place. But the problem is they're not challenging that. They're not challenging the validity or enforceability of the management agreement. The management agreement, the hotel has operated under that management agreement for a year, or did operate under that management agreement for many years before this issue arose in 2021. That management agreement was provided to lenders, to the franchisor. The Addies knew about it. And our position is they clearly consented to it. That was for that particular agreement. That was the agreement, notwithstanding that the proper partnership agreement said it should have had a termination for convenience clause in it. That's what they all acknowledge. We say they all consented to. At a bare minimum, Judge, they have waived and ratified it for leaving it out there for all these years. And we put in undisputed evidence of that. That alone would raise a fact question if they were challenging the validity or enforceability of it, but they're not even challenging it. And they don't even try to respond to that in their reply brief. They just ignore it again. So the fact of the matter is their complaint is Piro Aero shouldn't have entered into that agreement. And they say, well, Judge, in their reply, they even say, if you deny my summary judgment motion, we're going to sue them. Well, they've already sued them, but they're going to make some other claim against Piro Aero if you deny the summary judgment motion. That's fine. But at least let's have the case be about what they're really claiming and not simply ignore the terms of the management agreement and say somehow the partnership agreement that Aquila was not the party to, those terms come in and trump what your management agreement actually says.
Okay, all right. I want to hear. So explain what your argument is that 2.3 is not part of the agreement.
Sure.
I understand that argument.
That it's pretty simple, Judge. It's not in the agreement. 2.3. There is no 2.3 in the agreement. Period. And we put in the evidence to suggest.
So, Mr. Sokach, what is your response to that? Is it in the agreement or not in the agreement?
Well, no. So let me, and I'm glad you asked this, Judge. So let me clarify this. There's two management agreements. There's a 2014 management agreement that that the parties have fully executed copies of. There is a 2017 management agreement that does have this language from 2.3 in it that my clients submit has been executed by all the parties, but we cannot locate it. And we state this, I think it's on a footnote, and I think it's either our motion or our reply. We cannot locate the document. So the motion that we have submitted to the court is, okay, assuming that only the 2014 agreement is the correct one, we still win under the 2014 agreement. So I know that
the 2014 agreement does not have 2.3 in it.
It does not, Judge, but the outcome is still the same. It was a 30-day notice of termination. So so even if it's cited to 2.3 or it's cited to 2.7, if those clauses aren't in there, it still doesn't matter because it's form over substance. That was a 30-day termination notice. Is what it was. So the fact that it's cited to 2.3, which was in a 2017 agreement that we can't find and locate right now, that's fine, because at the time we thought that we were able and going to find a copy of that one that was executed. We have since not been able to locate it, but the fact of the matter is the remedy was still available under either agreement.
Your Honor, if I could quickly
Under
respond
what
to that.
section is the remedy available then under the 2014 agreement?
Of termination, well, Judge, it's under that 12.1B. It says that if there's going to be a defaulting party, then you have the ability to give a 30-day notice and terminate
Without cause.
without cause.
What's your response to that?
Your Honor, read 12.1. It's a default provision. It doesn't say without cause. It says if there is a
Can you
default.
share screen 12.1B? Ms. Munson, are you here for a hearing?
Yes, Your Honor, I'm a little bit early for the 2:30 status conference in Hernandez, and so then I just got caught up in the contract issue.
You fascinated?
I am sitting here on pins and needles. Thanks, Judge.
Judge, I did have just a brief reply whenever.
Yeah, go ahead.
So let me, while Mr. Collier is pulling this up, can I go back to my shared screen for a second?
Well, I want to see this first.
All right, then I can hold off. Happy to find it too.
1 second, I'm right almost there. So this is Article 12, default and termination. 12.1 contains the events of default.
Okay, so Mr. Sokach, what are you relying on out of here to say that this is you can terminate without cause?
It's in 12.1B. It says, and I don't know if Mr. Collier.
I've got it up now. It's at 12.1C. It says upon the occurrence of an
B
event of
or
default.
C? Do you say B or C?
Yeah, so it says, upon the occurrence
So
of
you guys are talking over, do you say B or C?
B.
B, okay. Let me read this. Well, it's upon the occurrence of any default, right?
Right, Judge.
That's correct.
Right, but the point is that if it's a cumulative right. It is a right. It is not exclusive. That's kind of our point on this, and that's why we highlighted that language. It's a cumulative right, meaning it doesn't have to be on this event of default. There's nothing in there that says that we can't terminate.
Judge, the language.
And it says may give. It's not a requirement. It's may give. That's the point that we were making on this.
And obviously, every default provision I've ever seen, a party is not required to terminate upon the other party's default. That's never the case. The point is, this is what gives them the right to terminate. And the language that Mr. Sokach is talking about being cumulative is in every default provision as well, because what it means is whether or not you terminate, you may have a cause of action for breach, and you may have other.
Mr. Sokach, so this is what you're relying on.
That's what we're relying upon if what they're saying is correct. If what they're saying is we had to give a notice, then we did give a notice. That's my point.
Okay, what gives you the right to terminate without cause? This section?
No, Judge, it's in the partnership agreement. That's again, go back to, it's in the partnership agreement itself. The partnership agreement expressly states, this is what I wanted to point out, Judge. The
Okay, go ahead now, you can point it out.
Yeah, the plaintiff is acting like Mr. Naik and Piro Aro and Aquila Lodging are three separate entities that are all operating at arm's length and have no idea who each other are. That's simply not the case, Judge. I don't know if you can see my screen up right now.
I can.
So here's what the agreement says. This is the partnership agreement. It expressly acknowledges that Aquila is an affiliate of the general partner. Let me where is this at? It's in section 2.1. It's in the definitions.
Right, I remember that.
So it says we are an affiliate, right? And it says as an affiliate, we are under unified, that's what the definition, sorry, Jim. This is what the agreement says. It says we are under the same control. We are controlled by under common control with the first person. We are the same entity. We are subject to the same control. It's not, they're acting like we don't know who Piero Aro is, and Aquila saying we don't, or Aquila saying we don't know who Piero Aro is, and Piero Aro is saying we don't know who Aquila is. We're third, we're separate and apart. They are all owned and controlled by Suhas Naik. That's why Mr. Naik executed.
Okay, I get that, but where does it say that you have the right to terminate without cause?
It's in section 7.1D6.
Okay, that's this part. Okay.
Correct, Judge. And this is the point is it's like the proverbial horse that's on top of a fence, right? You've got legs on one side and legs on the other side. It's like, hold us to the terms of this agreement, but don't hold us to the terms of the partnership agreement. That's their argument, is we want the management agreement to apply, but notwithstanding the fact that we executed the partnership agreement. It said we can terminate without cause and without penalty. Don't hold us to that. I mean, I guess my question back would be, well, what does this language mean then? What does this language mean if it says we can terminate without cause, without penalty? Are we just going to ignore that? I don't know what to say on that, because that's what this agreement says. That's what Mr. Naik agreed to when he executed these agreements.
What's your response to this in 7.1D?
Again, yes, Your Honor. Again, this is another provision in the authority of the general partner section of the partnership agreement. And it's saying, I'm certainly not saying that Aquila is not an affiliate. And I'm not saying we didn't know who Aquila was or any of that stuff that Mr. Showcast just said. But Aquila did not agree to this. The general partner and the limited partners agreed to this. And the complaint they have is that the general partner did not do what D says, which is make sure that the management agreement in particular had these conditions in it. Now we say that there's not a problem there because they consented to it. But that's not what the summary judgment's about. What the summary judgment's about is, did Aquila agree to this? And it clearly did not. And so that's the problem. And if they want to say this agreement was invalid, it was void, it was unenforceable because Mr. Naik and Piero Aro didn't conform with this when they entered into it, that's a different claim. They have not made that claim. The reason they haven't made that claim is they submitted it to their lender. They submitted it to the franchisor. They operated under it for years. But that would be the claim, not that Aquila's management agreement now doesn't say what it says. That's the problem.
Okay. All right. Well, this has been very well argued on both sides and good PowerPoints. I'd like you to go ahead and email in one email both PowerPoints to Rhonda, my court coordinator. Let's see, when is this case set for trial?
It's not till September or something, Judge.
Okay. We will try to get you an answer on this within the next 3 to 4 weeks. And if both sides submitted orders.
We have filed one.
I think the plaintiff did. I will do that immediately after I get out of this hearing.
Okay.
And Judge, you saying you want both PowerPoints in the same email?
I'd like to, no, I want to, so this is what I want. You guys provided me all the briefing. Send me both PowerPoints in one binder with all highlighted cases, because I think it was just lost in translation. I'm not fussing with anybody, but I think I'd requested highlighted cases from whoever sent the binder. I'm not upset with anyone. I don't yell at any paralegals or whatever. It may not have been clear, but I wanted highlighted cases that were cited in this. So if you guys want to work together, send me both PowerPoints. I don't need the briefing again. You already sent that with highlighted cases. We'll try to get you an answer within the month.
Okay.
So, and Judge, last question. When you say to Rhonda, I thought at first you said email. Now you're saying you want a binder.
No, I'm sorry. I meant send to Rhonda. Send her a binder that has both PowerPoints and the highlighted cases in them.
We can do that.
Okay.
And just try to get that as soon as you can. All right, guys, but good job arguing this. I think it's very well done. It's kind of a complicated issue, obviously. We'll try to get you an answer as soon as we can.
Thank you, Judge.
Thank you, guys. Good job. Ms. Munson, Mr. Tolles,
Yes, Your Honor.
are y'all here for the 2:30 status conference?
Yes, Your Honor.
We're way more exciting than that, Judge.
I don't know about that. That is an unusually complicated contractual argument, though, with the two competing contracts and the missing contract. And there's a lot to this.
And the partnership agreement over on top of it all.
Yeah, it's yeah, exactly. All right, so my computer's not working.
And thank you for accommodating us, Your Honor. I appreciate it.
Yeah, so I apologize. I cannot get my case management system up. Remind me what this is about. I know it's a status conference.
Your Honor, you appointed me as the guardian ad litem. Actually, Judge Aceves was initially the ad litem. And then when she was elected to the bench, I substituted in. We also have a pending trial setting, but really just an issue as far as the medical and billing records. And there's some records that have some issues, and just wanted to try and get in front of you, Your Honor, just so we could kind of have a quick discussion, so to speak, so you'd kind of know where we were. I didn't want you to think it was a situation where I wasn't doing my job, just trying to get this to the finish line.
All right, so explain a little more detail what's going on.
There's some deficiencies, Your Honor, with some of the medical and billing records related to one of the minor plaintiffs.
Okay, and what do you mean?
The records are not accurate. More specifically, they don't belong to the minor plaintiff. So Ms. Morgan and I had a conversation previously. She was working to try and get that resolved. I think she's had some hurdles that she's encountered in her efforts to do this. So really just kind of coming to you to kind of let you know where we are and let you know we're all kind of working efficiently, but having some issues. So I'll stop talking and kind of defer to Ms. Morgan to let you know what she's been doing on her end.
So, Your Honor, the issue that we have here, and I don't know if you can recall trying to assist us in clarifying some liens a few months back. So the liens, the hospital bills, from what we understand, had been paid. There were two different minors. One had serious injuries as it relates to this motor vehicle collision, another not so. So settlements were I guess, discussed and resulted based on that information. We found out originally we believed that there weren't liens attached, that had been worked out with the father whose insurance this had been paid through, but Rawlings, paying on behalf of Aetna, has in fact let us know that there are some liens. Now, the medical bills for the two daughters have actually, it looks like they've been reversed. So the daughter with the more catastrophic surgery needs, it looks like the lower medical bills were assigned to her case and then a lien placed on that. And then the daughter with not so serious injuries, it looks like those medical bills that were higher attached to her case and then a lien placed on that. So I think we've gotten to the point where we understand that the liens and the medical bills are incorrect and improper, but now the issue in getting them requested and worked out, sorted, so we can correct the liens and then ultimately have true and accurate reductions in settlement figures is that the mother, who was also involved in the collision, was the guarantor on the medical bills at the time, not the father who we actually represent. Now, the relationship between mother and father, they are divorced and they don't have a good relationship. Our office, so we have father who should have every right to bring a settlement or reach settlement on behalf of the daughters. Ready, willing, has signed off on multiple HIPAA forms to get corrected medical bills, records, and things of that sort. But the hospital is now coming back and saying, in order to get clarification on bills. The mother, who was guarantor at the time, has to sign, and she's just not cooperating. So we've text messaged her, we've emailed her. I believe, I don't want to misspeak, but I believe even Mr. Tolles has tried to reach out. I could be wrong there, but I think he has as well. And so there's been several
Correct, Your
attempts,
Honor.
to try to push the needle for your court to say, hey, this isn't even about us or father or ex-husband that you don't have a relationship with. This is about your children. We need your signature to be able to get these medical records so we can effectively reach settlement. And she's just not responding. So what I'm trying to do next now is I believe, and I'm clarifying this with the father, that there was not in the original divorce decree and custody issue, but subsequent custody agreements, he may actually have documentation saying he has the right to make medical decisions and things of that sort. So if I can maybe submit that with a letter to Rawlings and the hospital, that may help clarify the issue. And that's what we're going to work on this week. We're just trying to troubleshoot every way we can to get the hospital to release the medical bills and allow us an opportunity to correct that. So I'm sure Your Honor can imagine, they put their liens, they want their money and all of that. So it's a little bit hard. They haven't been.
Is the issue with the hospital or with the health insurance? Did the hospital put the bills in the wrong name, or did the lien attach because Rawlings did it wrong?
I don't know, and I think that's been the most challenging. I'm making a huge.
I think it's the
assumption here, but
hospital.
I would assume the hospital did it wrong first, and then that's what the lien's attached to. So it's hard for me to go back to the Rawlings.
Do you not have a copy of the hospital bills and records?
I don't have a copy of, what am I missing? I am missing a copy of, and I just lost the email. Let me see. I'm missing a copy of the billing record. So I have medical records for Cadence, who was the most seriously injured, but we're missing their most up-to-date billing record for her. And then it's the vice versa on medical records for Kaylee. Now, I believe all of this had been requested. True transparency before the court, I cannot find it if it did ever come to our office. So we're trying to re-request it. But that is the biggest issue. So it's hard for me to go to the lien holder and say, your lien has to change because it was the hospital who placed it under.
Has anyone talked to Rawlings about this?
Yes, and Rawlings has confirmed the amounts and that there is liens, but they want to see the billing records to clarify that they need to make those changes. They're not just going to go off of my words.
But you have the billing records, right?
No, that's what I'm needing. That's what I'm trying to get for.
You just said you had. Okay.
Right, and so I'm to the point of like I said, I'm going to look through the not only the original divorce decree, but I believe there was subsequent back and forth, and to see what that final ruling was. If in the divorce decree there is language about medical decisions and things of that sort. But I think we're almost to the point of knocking on mom's door, even though that's unwanted. She's making it very clear she doesn't want anything to do with us or this, which I believe she was even a party to this case. So,
Ms. Munson, let me ask you this. What do you need to get this thing done?
Yes, thank you, Judge. So I need a signed release. I need the liens, whatever they may be, taken care of. And we do actually have mom and dad are parties to this case. So we're going to need mom and dad to sign off on this case. Here's, Judge, if I may, just a suggestion that might kind of short circuit this. It sounds as if what we need are the medical records from Kaylee, who is not before this court, and the medical records for Cadence, who is before the court, and medical bills for Kaylee, medical bills for Cadence, because those are the two that the hospital apparently has gotten mixed up, which has then resulted in Rawlings having different and potentially incorrect lien amounts for the kids. With that said, because there apparently is an issue with mom, I don't know if this would work, but potentially because Mr. Tolles is the ad litem, it occurs to me that the court could probably enter an order that says any medical providers who provided treatment to Cadence and Kaylee, you know, full names, date of birth, as a result of the accident on such and such date, are ordered to turn those records over to Mr. Tolles. Because the court, I would think, has that authority, and then that might short circuit this whole issue with mom. Once that's all resolved, such that we can figure out, or they can figure out what is actually owed for Cadence, at that point, we set a hearing, we subpoena mom, and by we, I really mean Ms. Morgan, but whomever, we subpoena mom. If she doesn't come, the court then can say she takes nothing. I get dad to sign off on the release. He has authority to sign off on the release.
Is one of
And
the
we can
children
approve
over
that.
18? Is that part of the issue? Is one of the children over the less hurt child over? Are they both under 18?
No, they're both under 18. For whatever reason, the insurance company did not feel that the damages to Kaylee were sufficient to warrant approve up of a settlement amount. Wasn't involved in that decision, not my issue for that settlement. So the settlement here is policy limits for Cadence. But nobody's over 18.
Ms. Munson.
Your Honor, I have the medical records. I have the medical records for Cadence from Scottish Rite. Judge Aceves sent those to me when she sent me kind of her file, but I don't have them for Kaylee, just so you understand, Judge.
All right, so what we're going to do, I've done this before and it usually works, and none of you is going to like it, but it's what we're going to do, is we're going to have weekly status conferences on this. So every week we're going to be meeting and give me updates on what's going on. For the next status conference, Mr. Tolles, I hate that you're not getting paid for this, but Mr. Tolles, you need to send the Zoom link, we'll do this over Zoom, to the mom, to the dad, to Rawlings, whoever the rep is for Rawlings, because I want to talk to them. Send it also to the hospital and say the judge has requested all of you to appear. We're going to do this again on the 10th at Rhonda. Are you there? Rhonda, are you there?
Yes, Judge, I'm here.
Okay. So I want you to put in the notes that we have a status conference on this case next Monday at 2:30. And put in the notes that Rawlings, that's RAWLINGS, mom, dad, and hospital all required to appear.
Okay.
And then set a status conference for the 10th at 2:30, for the 17th at 2:30, and for the 24th at 2:30.
Oh, that's one for the 10th, the 17th, and what else?
And the 24th, none of these can be canceled without court approval, without judge approval.
Okay, cannot be canceled. And all of them are gonna be at
2:30.
Judge, I'm set for trial on the 24th in Judge Slaughter's court, numero uno.
Hopefully you'll be done by then.
Enough, Your Honor.
We'll cross that bridge when we get there. So
Yes, sir.
Judge, what do you think about that order? Would you like?
I
me to
think that's a
draft
great
one?
idea. Prepare an order for me, Ms. Munson. Because at least you're getting billed by the hour instead of Mr. Told, who's going to have to donate all his money to the Alberta Foundation. But that's, how these work out sometimes. So prepare the order. I will sign the order. Try to get that to me as soon as possible. Share it with Mr. Tolles first, just so he's okay with it. And Ms. Munson, if you have any, I thought you had a great idea there. We need to cut through all of this. We need to get this thing down so these kids, this money can go in the registry of the court and these kids can start earning interest. So this has been going on way too long.
Yes, Your Honor.
All right. Any questions, guys?
Thank you.
No, Your
Your
Honor.
Oh,
All right.
one question.
Mhm.
Can the court move our trial settings so that we don't have?
Nope.
Okay,
Nope. We're going to get this done before then. I have faith.
I hope so, Judge.
No moving.
Thank you, Your
out.
Honor.
We're gonna be meeting every week. This is gonna be something you guys look forward to all week.
I definitely will, Judge.
Always,
Yes.
Your Honor.
You always look, I know you always look forward to seeing me, but we're gonna be doing this. This is gonna be something we look back on with fond remembrance.
We can laugh about it at the bench bar.
Yes, that sounds like a great idea. Sounds like a great
All
idea.
right.
You guys have a great week. We'll see you next Monday.
Thank you.
Sounds
all.
good, Your Honor. Thank you for your
Thank
time.
you. And
Thanks,
make sure
everyone.
that you have with you next time, if they don't show up, I want the phone number for mom. I want the phone number for Rawlings and whoever the billing person is who you notify. I want them, us to have their phone numbers because I'm going to call them during the hearing if they don't show up.
Great. Thank
All
you,
right,
Your
Your
Honor.
Honor.
Thank you guys. We'll see you next
Thanks,
week.
Judge.
Thank
Okay.
you.
Bye.
All right. There's an ML here. Oh, okay. We have who ML is. Okay. All right. We have a hearing again. This is a good time to take a break, Tony. We have a hearing again in 15 minutes.
Sounds good. Okay.
Okay, is everyone here for the 3 o'clock minor prove up?
I am here for that hearing, Your Honor. I see Garrett Mize for the plaintiff and Mr. Alexander for the defendant.
Okay,
Hello, Your Honor. Yes, this is Garrett for the plaintiff, and I believe that my client should be logging in momentarily.
okay. And what about the defendant?
That's me, Your Honor, William Alexander.
Okay, so and is Miss Flores, is that the plaintiff?
Miss Maldonado.
So I have an Ismael Flores here. Is that your client?
I believe that's the interpreter.
Are you the interpreter, Miss Flores or Mr. Flores?
That may be, let me see here. That may be Miss Maldonado. She and I spoke on the phone, but she may be using a different account.
Ismael Flores is my husband.
There you go. Thank you, Miss Maldonado.
Okay.
I'm ready to proceed when you are, Your Honor.
Okay, let's go ahead and then everyone's here and ready to go. Tony, let's go on the record at DC 222346 Maldonado versus Hernandez. Counsel, make your appearances.
Rocio Goswer Hernandez. I'm the ad litem on this matter for the minor.
Garrett Mize on behalf of the plaintiff.
William Alexander on behalf of defendant, Your Honor.
And Your Honor, the ad litem would call Ms. Maldonado, who's listed as Ismael Flores on the Zoom as a witness.
All right, ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. If you could please state your name for the court record.
Natalia Maldonado.
Ms. Maldonado, are you AJ's mom?
Yes.
And you're the same Natalia Maldonado who's filed suit as an ex-friend of AJ?
Yes.
Does she currently live with you?
Yes.
And is this case based on a car wreck that happened that she was involved in May 2, 2021?
Yes.
And was your daughter AJ in the crash that day and injured as a result of the crash?
Correct.
Are you confident that AJ has recovered from her injuries that she suffered in the wreck?
Yes, I have.
And it's your understanding she doesn't need any future treatment for those injuries, correct?
Correct.
Right. And are you here asking that the court approve a settlement with the defendant, Jose Hernandez, for all claims that AJ could have against the defendant?
Yes.
For a total settlement amount equal to $30,000.
Yes.
And you understand that the law office, Jim Adler and Associates, for which Mr. Garrett Mize is here, will receive their attorney's fees of $10,000 and case expenses of $113.59 out of that settlement.
Yes.
And in addition to that, their total medical care and expenses of $2,642.41.
Yes.
And there's a huge reduction of the Medicaid lien from $23,000 and some change to $2,297.97. That's going to be paid out of the settlement.
Yes.
So the net amount due to AJ would be $14,946.03.
Yes.
Are you asking the court to approve the settlement?
Yes, please.
You understand that money belongs to AJ and to no one else.
Correct. I do.
And that's the recommendation of the ad litem to put that money into an annuity with Pacific Life so that AJ will ultimately receive $16,219.44.
Yes.
You do also understand AJ will not receive the first payment until her 19th birthday, so she can receive her full Medicaid benefits, correct?
Yes, I understand.
Do you understand that rather than entering into a settlement on this case, you could have a jury trial where you might receive more, less, or no money at all for AJ's claim?
Yes.
And have the settlement documents all been explained to you?
Yes, they have.
Are you in agreement with the settlement agreement and release?
Yes, I agree.
Do you understand the court would not approve the settlement without you desiring to do so?
Yes, I understand.
And it is your request that the court approve the settlement agreement?
Yes.
Okay, I'll pass the witness.
I have
Your
nothing to ask, Your Honor.
Yeah, Your Honor, I don't have any other questions either, and I appreciate the guardian ad litem for her thorough questions.
All right, so I have a question here, and I'm looking at the agreement, the proposed order approving settlement, and maybe I'm just missing something. There's a $30,000 settlement, is that correct?
Yes, Your Honor.
And then there's the lien holder is going to get $2,297.97. Is that correct?
Yes, Your Honor, that is correct.
And then Adler and Associates is getting $10,113.59. Is that correct?
Correct. Yes, Your Honor.
And then the annuity was funded with a payment of $14,946.03. Is that correct?
Yes.
So according to my math, that adds up to $27,357.59. Where did
Your
the
Honor, if I might pipe in. So the medical expenses versus the lien are tallied separately. So the Medicaid, $2,297.97, that's completely separate from, there's a few other providers that didn't go through Medicaid, and they have another total that's over 2,000.
So, but that's not anywhere here in the judgment.
Let me see.
It's under providers,
Where?
first page, very bottom.
Oh, is that providers and then lien holders are separate? Okay, I get it. All right, I misread that. Let me see if that number adds up. I thought that was a reduction, the lien holder reduction. So those are two different numbers. Okay, the numbers add up. All right, Ms. Maldonado, do you have any questions for me?
No, not today. Thank you.
I understand. Is there a recommendation of the guardian ad litem?
Yes, Your Honor, that the settlement be approved with the annuity with funds to be released to the child in twice a year payments in March and September, once she turns 19 years old, so that she can finish out her Medicaid coverage.
Okay. And is this, I see a proposed order approving the settlement. Does that take the place of a final judgment, or is there going to be how are you all doing this?
Your Honor, yeah, go ahead. Go ahead, Bill. I'm sorry.
Yeah, we were going to have the court approve the settlement, and then once all the funds are dispersed and everyone's got everything, the plaintiff would file a dismissal of prejudice.
Okay. So this does not dispose of the case.
No, this order will not, and it won't dispose of the case until everyone has received their funds for disbursement. Pacific Life has got the money for the annuity. Adler has their money, all that.
Okay. In the future, I mean, I'm not going to make a big deal about this. I'd prefer to do this in the form of a judgment unless there's some reason not to in this case, but it's just, I think it's quicker and cleaner, but this is fine. Unless, why are y'all doing it this way? I guess it's not how it's normally done.
Actually, this is the way I've always done it, Your Honor, but I think it also ensures that everyone gets their money before the case is dismissed.
Okay.
I understand, Your Honor. My preference is to do a final judgment rather than a subsequent dismissal. But I understand, Mr. Alexander's request for it. And so, given his, his custom of doing it, we're fine with that. But I typically also will customarily do a final judgment. But I'm fine either way.
Yeah, I mean, it would make sense that you do a final judgment, but it's up to y'all how you want to do it. And I understand that the guardian ad litem fees are agreed to at $1,400. Is that correct?
Yes, Your Honor, and I did reduce since I'm the second ad litem on the case. As you know, one of the ad litems is now your colleague, so.
Okay, you took over for Judge Savis. Okay, good. All right, well, I'm glad we got this one done, and appreciate your service. We will. You guys are excused, and I've already signed the proposed order, and it's been sent to the clerks.
Thank you, Your
Wonderful.
Honor.
Thank you, Your
Thank
Honor.
you.
Thank you.
Thank you, Natalia. Have a good day, Ms. Maldonado.
Thank you. You too. Bye-bye.
Goodbye.